Hi, everyone. I guess we can get started. My name is Julia Williams. I'm the editor-in-chief of Brooklyn Law School's Journal of Law and Policy. First, I'd like to thank all of you for tuning in, and I'd also like to thank our panelists and our moderator for participating in what I know will be a great conversation. Note that you can ask questions in the Q&A throughout, and we'll make sure to leave some time at the end to address some of those questions. Before we get started, I'll just let each of our panelists and our moderator briefly introduce themselves. So whoever wants to start can go ahead.
I can go ahead and jump in. Hi, everyone. I'm Lisa Washington. I am an assistant professor here at Brooklyn Law School. I teach criminal procedure and evidence. Before I went fully into academia, I was a public defender with Bronx Defenders, first in the criminal defense practice and then in the family defense practice. I then directed the family defense clinic, or co-directed the family defense clinic with another colleague at Cardozo. The only thing I'll add is that I focused my PhD studies on negotiated outcomes in criminal procedure in Germany and the United States, and ineffective assistance of counsel happened to feature pretty prominently in that thesis.
Hi, I'm Molly Parmer. I'm really honored to be here alongside these esteemed panelists and Lyle, who I haven't met in person, but have had some communications with. So it's really an honor to be here. I own a law firm in Atlanta where I am, which specializes in high stakes criminal defense, predominantly in federal court. But I started my career as a public defender on the county level in Atlanta, and then became an assistant federal defender and worked for 5 years in that capacity before launching my firm. I'm an adjunct professor at Emory Law, where I teach advanced criminal trial practice to 3 Ls. I am on the board of directors of the Georgia Innocence Project, and I also am a television legal and analyst. And tonight, after I leave this panel, I'll be going to Court TV, where I'm on every Wednesday at 9 p.m. So honored and thrilled to be here.
Thank you. My name is Alexis Hoag-Fordjour. I'm an assistant professor at Brooklyn Law and co-direct our Center for Criminal Justice, along with Professor Simonson and Professor Mogalescu, who's not on this call. Before academia, I spent over a decade in practice, first as an assistant federal public defender in the death penalty unit in Nashville, Tennessee, in the Middle District. And then I did racial justice and civil rights work with the NAACP Legal Defense and Educational Fund. It is a real honor to be back in conversation with Lyle. He spoke to my students while I was in a fellowship at Columbia Law School, and really added an incredible element to our class that can't come from necessarily a professor in the readings. And so it's exciting to be back in conversation with Lyle. My scholarship is mostly devoted to the Sixth Amendment right to counsel and its related jurisprudence, and looking at the failures of the ineffective assistance of counsel standard and how it's really stacked against defendants. So this is a topic near and dear to my heart that I'm really excited to participate in. So thank you.
Lyle, can you introduce yourself?
Sure, I can unmute you now.
Yeah, we're unmuted.
Hi, my name is Lyle C. I am incarcerated in North Carolina since 1997. I was 19 years old. I've been on death row since 1999. I've lived through 33 executions during my time here. Fortunately, executions have been in abeyance since 2006. During my time on death row, I've been fortunate to have had access to higher education and have managed to complete an associate's degree, and am currently working on finishing a bachelor's in specialized studies in criminal justice administration. A large part of what I do, my writing, is an extension of what I've learned, not just in my coursework, but experience here on death row and through the lived experiences of my peers. It is very much about survival for me. So these are survival skills and that is where my writing comes from. So I also engage in a form of journalism, the kind that generally prison officials don't appreciate too much, and it is often hard to get published because it is counter to that mainstream narrative of crime and punishment.
Great, thank you so much. And for those of us on Zoom, we're seeing Lyle's picture, and he is calling in from where he's incarcerated, and we're relaying that phone through the Zoom. I can hear you great. If anyone is having trouble with the audio, put it in the Q&A and we'll try to figure it out. Terrific. So I'm Jocelyn Simonson. I'm a professor here at Brooklyn Law School. I co-direct the Center for Criminal Justice. I'm a proud faculty advisor of the Journal of Law and Policy. And I did want to name what part of the reasons we're here and in community is that Lyle May is publishing an article that's forthcoming in the Journal of Law and Policy that circles around these very issues. It's called State of Delay: Our Outdated Capital Post-Conviction Defense Tactics Undermining Effectiveness and the Attorney-Client Relationship. And it's phrased as a question, but I don't want to spoil it too much. So the answer is yes, they are undermining it. They are undermining it. And the article, keep an eye out for it. It brilliantly weaves together issues of post-conviction appellate law, ineffective assistance of counsel, strategies in capital defense cases, conflicts of interest, and then just sort of real on-the-ground realities of what it's like to have a client-attorney relationship. And so that's what brings us here today, to talk, yes, about one particular case, but also recently in the Supreme Court, but also more broadly about attorney-client relationships, especially but not only in the context of capital defense. As the moderator, I'm going to read through a series of questions, but we encourage people to bring in their own subjects or questions at any point. And I didn't make up these questions. These questions are coming from Lyle, who really set us out with an agenda to think critically and collectively about these issues. So I am going to start us off with a question that will hopefully get at all four of your rich experience. All of you have years and years of experience. I guess I didn't say that I spent 5 years as a public defender, which is experience, but really pales in comparison to the many years that all of you have circling around these issues. And I never did do appellate work. I did it on the trial end. So to think about the attorney relationship in the appellate context is really important and doesn't always come up when people talk about attorney-client relationships. So the first set of questions, and Lyle, I would love to start with you, but hear from everybody from whatever perspective and experience you come from, is about your own experiences with attorney-client relationships and the kinds of lessons, sort of big or small, that you might take from them. So here's how Lyle phrases the question. Attorney-client relationships can be difficult to develop. Some clients are difficult, mean, mentally ill, intellectually impaired, deceitful, or some combination of the above. Other clients are none of these things. Some attorneys are stubborn, arrogant, mean, deceitful, dismissive, incompetent, or some combination of the above, or all of the above, you forgot to say. Some attorneys are none of these things. I would say all attorneys can be some of those things at some times. And both circumstances make adequate assistance to a case and defense of a client difficult. It can erode the ideal of zealous defense, but one common theme with all clients and attorneys is that effectiveness depends on communication. So the question for all of you is, what are some difficulties you faced in the attorney-client relationship, and what are some specific steps that could be taken to resolve it? Thinking that we have some law students zooming in to listen to our conversation. So Lyle, I would love to start with you.
Sure, thank you. Thanks for the question. So oftentimes, communication is about being willing to listen, and of course that's difficult when you have some circumstances or characteristics of an individual that are that stubbornness or arrogance or mental illness certainly make that difficult to process. found is best for communication is repetition. It's good to repeat yourself. Make sure that you're being understood. And if you're not being understood the way you say it the first time, maybe find different ways to say it. It's also good to be calm and rational when you're trying to communicate. And I know, again, that's not always easy when they have a client who's mentally ill or intellectually disabled, or totally set on their opinion and unwilling to listen to alternative opinions. So, of course, listening is certainly central to that ability to resolve conflict. And it also means focusing on a higher goal. What is the goal of the client? And I think this is where a lot of the conflict often occurs, is that maybe there's not a complete understanding of what the goal is. I know for myself and a number of peers, avoiding execution is not the goal. It's a goal, but not the goal. And that's something that I certainly stress in the article that I'm publishing with the Journal of Law and Policy, is the need to, maybe get a firm understanding of what the client's interests are, and then go from there, as opposed to what has been embedded in the thinking of a particular attorney for a given case. I think, especially when it comes to capital post-conviction defense work, that there's often a loss of maybe interest in what a client has to say, because an attorney may be more focused on simply trying to avoid execution. And I think it's important to find out what the client wants, and that would often resolve a lot of conflict. But when there's that effective communication, when there's that back and forth of ideas, when there's careful explanation of why an attorney might or might not do something, I think that goes a long way toward resolving conflict.
Great, thanks for that. Professor Washington, I'm going to pass it on to you to build off of Lyle's response.
Yeah, so I'm going to pick up on a couple of things that Lyle said, because a lot of it really resonated with me. I think about this question from a perspective of a public defender, right? And so many people, or everyone who I have represented, did not explicitly choose me as their attorney, right? The state assigned them to me, and they really had no choice. And so I think that's important to recognize as sort of the foundation of that relationship. As sort of the quote unquote experts, I think sometimes assume people are just supposed to trust us. We're strangers to them, right? They've never had a conversation with us before. We've never represented them, their family members, or anyone else, most likely, right? So we don't come with this recommendation, and understanding that when we have our first conversation with people, it's totally normal, actually, to be distrustful of us. I think we are just one of the people that they meet on a really terrible day, right? Often, right? If we're meeting someone in arraignments, for example, I'm thinking of the trial level now. And so I think that's a relationship that has to develop over time. And I think attorneys have to earn trust, right? I think seeing that you're actually fighting for someone, and that you're, what Lyle mentioned about sort of focusing on what the actual goal means, to me means client-centered representation, right? So identifying not what I think the best goal is or the ultimate outcome, but identifying what this person wants, and being able to take a step back and say that at the end of the day, that is that person's life and their choice. And they're weighing a lot of things, right? And so to figure out how to build in strategies that will center the goal of the client is really important. And often those relationships just sort of develop over time, and sometimes slowly.
Great, thanks. Molly, how about you?
Well, I think what Professor just said is exactly on point. And to kind of further develop, from my perspective, it's been interesting because I was a public defender for years, but before that, I grew up in poverty with a parent in and out of jail. And so if you come from that background, I think that I identified a bit more with the distrust of the government. That's how I was raised, and things that the government gave us because of our indigency were not of quality. So I understand, I think, or I did understand as a public defender, why there would be this inherent distrust. It's not based on the attorney that walks in the room. Of course, you don't know them, but it's these layers of experience that you've had for years before you meet this person. And one thing that always, I think, you know, as a public defender, being in the room with other public defenders talking about our clients or our cases or working through issues, it always struck me how sometimes my colleagues or my coworkers would complain about how their client was lying to them as though they automatically deserved the truth. And I think that that's something that you have to be really careful with if you want to be a public defender, because you have to, just like what the professor just said, you have to earn that trust. And you don't want to start off in this position where you have expectations that you're going to save the day. You're going to walk in there and be so well received, and your client's going to be absolutely transparent and honest with you from day one. Because then what I've seen happen is that an attorney sometimes feels, you know, they feel in some way that they've been wronged because maybe their client misspoke or misstated something or lied about something. And then they come back and say, well, you said this, and kind of engage in this back and forth that further erodes the relationship. And so I think you have to go in there realizing that your client is a collection of experience just as you are, and they don't know you, and you do take that time. And if it does require a long period to finally get to where you need to be, to dig in and to have that trust, that's okay. You know, take that time and manage your time well in order to do that.
Professor Hoag-Fordjour.
Thanks. Generally in practice and in my scholarship, I think about these issues from the posture of post-conviction. And so the timing, the environment of the initial interaction is different. Professor Washington spoke about you know, the real moment of crisis at arraignment, at that first appearance. And there's a different sort of slow violence to the crisis of, you know, being convicted and then sentenced to death. And so that was the point at which I was meeting my clients. And something that I recognized is that I was likely the 7th, sometimes 8th attorney that had worked on their case. And so it wasn't that I was just introducing myself, is that I was having to introduce myself and then overcome sort of the negative experiences that my client may have had with their trial lawyer, their direct appeal lawyer, and their state post-conviction lawyer. And because it was a capital case, there are often 2 lawyers. So here I was, number 7, number 8 coming in. I approached my initial meetings with clients with a lot of humility. I was definitely not the expert. I wasn't coming in with, you know, expertise and I'm going to tell you everything I know. The initial posture and most of my meetings involve me listening a lot and not talking, which I think as lawyers can be hard to do. We do like to talk. I think keeping sort of my mouth shut and trying to listen. Early lessons that I gathered in client interactions is that admitting what I didn't know went a long way. And so my clients, you know, would ask for something specific from the record from state post-conviction. If I hadn't read that volume of the record, I wasn't going to pretend that I had. And so I'd say, you know, I actually don't know the answer and I have to get back to you. And then if I said I was going to reach out to a family member, if I said I was going to talk to a witness, then I would do it. And if I couldn't do it, I wasn't going to say that I was going to do it. And that went so far in terms of establishing trust. It was okay if I said, you know, I'm really busy, I'm not going to have time to do that, but to at least tell my client, you know, I'm not going to be able to get to that would go a long way. I think early on in my practice, something that I had to overcome was that I looked really young. So 15 years ago, I didn't quite look like I had graduated law school. You know, and I was meeting clients who had been incarcerated for longer than my own life, and being able to establish trust so that they could trust me as their advocate and as their lawyer was a little bit of an uphill battle. But the showing up, following through, let my clients know that I was someone that they could trust. And you know, there's a version of that that can exist even with shorter periods of representation at the pretrial stage, even though my experience is largely in post-conviction.
Great. Thank you, everybody. So I'd love to keep this conversation about relationships going, but bring in recent Supreme Court cases and the relationship between the law and constitutional rights and some of these relationship issues. So as the title of the panel, is a nod to, recently in Shinn v. Ramirez, the Supreme Court came out with an opinion. It was actually two opinions. I think Jones was the other one. That placed real limits on the ability of people who in their own post-conviction proceedings in federal court to raise ineffective assistance claims if they haven't already been developed or raised in state courts. And on the one hand, the Supreme Court is saying that it's interpreting a federal statute, the Anti-Terrorism and Effective Death Penalty Act, but it is really about the constitutional right to counsel and to effective assistance of counsel, and limiting the ability of people to bring up those questions at a later time. And so it's worth thinking about both the effect of Shinn and then the relationship between that and between these questions about relationships we're talking about. So Lyle puts that relationship question this way. In light of Shinn, is it incumbent upon defendants to know their case and hold their legal representatives accountable when the defendant's interests are not being met? For example, if an attorney ignores a client for years, leaves critical information out of a brief, fails to investigate a witness, or subverts the client's interest for a third party, should that defendant file complaints with the court or even have counsel removed in order to establish a record of conflict at the state level? Lyle, I would love to hear a little bit more about this question and your answer to it.
Sure. So this question does not arise from some fantasy island. These are real examples of problems that people in prison.
You have 60 seconds remaining.
We're now face. And what Shinn has done is basically signaled to us, those of us who are facing these sentences and are trying to get our cases overturned, it signals to us that we're basically in this, we're going to face any error that our attorneys commit, whether that's through negligence or
you have 30 seconds remaining,
or simply overlooking something. It happens. People can make mistakes. But unfortunately, what Shinn tells us is that those mistakes are going to be held against us. So what that then means is how do we make sure that our attorneys know that they're doing this? Hold on, hold on.
I'll let you know when he's back.
Okay, thank you.
Okay, great. Yeah, so Professor Hoag-Fordjour, can you jump in while we wait for
Yeah, and while we wait for Lyle, I can give a little bit of background on Shinn versus Ramirez and Jones. It's a capital appeal from two separate petitioners that were both sentenced to death in the state of Arizona. And David Ramirez had a claim of intellectual disability, which would have made him ineligible for the death penalty. And Barry Jones had a claim of actual innocence, which would have made him both ineligible for the death penalty and also he wouldn't have been convicted. And because the U.S. Supreme Court found that they were essentially at fault for not raising claims of intellectual disability and actual innocence in their early stages of their trial, direct appeal, and state post-conviction, the U.S. Supreme Court majority said, they were procedurally defaulted. They had sort of an obstacle in place from raising these issues in federal court. And Professor Simonson already named the statute, the Anti-Terrorism and Effective Death Penalty Act, or AEDPA, 2254, and this is focused on subpart E2. And it's frustrating, not just for lawyers navigating these issues, but for folks like Lyle, like Mr. Ramirez and Jones, who have credible claims that could stop the state from executing them, but because they essentially had ineffective assistance of counsel, during the early stages of their appeals process, and the state court didn't get a chance to look at the issue. Now a federal court can't look at it. And this idea of who is at fault. Clients who are sentenced to death and incarcerated don't have access to resources and investigators to navigate the claims and work up legal claims, or perhaps don't have access to materials to file in court. Sometimes state courts are really hostile to pro se litigation, and so they're completely dependent on their attorney to provide effective representation. And when that doesn't happen, failings of the lawyer could be attributed to them now in federal court. And the US Supreme Court has leaned, the conservative majority has leaned quite heavily on concepts of federalism, that federal courts shouldn't intervene in what's happening in state court, and comity. And a complaint that Sotomayor and others have had, and she dissented in this case, was that it shouldn't matter, essentially whether you have engaged in an aggravated crime or not. You are entitled to effective representation, and these ideas of federalism shouldn't stand in the way of the state providing indigent people effective counsel. And I just want to focus and name, and I think we've been talking a lot about, obviously appointed counsel, lack of choice, indigent defense, is that you're not seeing people that had that paid for the lawyers sentenced to death. It's really a population of people that are most marginalized in our society. And I don't know if we have Lyle back on the phone, but I'd love to get back to him.
Okay. Sorry about that. So with regard to Shinn, I think the emphasis here is that the defendant must do everything he or she possibly can to be aware of what's going on in their case, and to make sure that counsel is aware of their interests. And if there isn't a good communicative relationship, then it is absolutely dependent on the defendant to pursue every available avenue to ensure his or her interests are being met, and when they're not, that they're being heard, whether that is through pro se motions in court or removing counsel if necessary, but only certainly as a last resort. I'm not an advocate for removing counsel. I believe that oftentimes, and I've seen this happen with a number of my peers who tried to remove counsel, that it creates more problems than it solves. That being said, if you have an attorney who is leaving things out of a brief, if you have an attorney who doesn't even bother to communicate with you and kind of treats you like that redheaded stepchild, then you have to do everything that you possibly can, because at the end of the day, it's your life on the line, not theirs. So in that sense, I think Shinn creates a different kind of problem. Certainly, the lack of federal oversight is problematic in state courts when in state courts you have these ineffective counsel issues, but creates a different problem in undermining the relationship of the attorney and the client to begin with, because now, for those defendants who are aware enough of their case and of their attorney's dealings on their case, I think it potentially undermines trust, because the defendant's going to second guess what an attorney is doing or is not doing, or when an attorney fails to communicate effectively, or does not follow up on an interview, or doesn't do something that the client thinks he or she should be doing, then necessarily creates greater problems.
Great, thank you for that. Molly, do you have any reactions?
I think it's interesting having practiced both in the state system and the federal system. And as a state court PD, I had 250 open felony cases, right? So if we're thinking about, and in federal court, I had like 20 to 25. If we're thinking about state courts, and if it is now incumbent, as I think that, Shinn v. Ramirez has put us in the position that Lyle just artfully described, for our clients to bring this to the attention of the court. I think we have to not take it personally and sometimes fall on the sword. And maybe there does need to be a record of the PD themselves saying, Your Honor, I have 300 cases right now. And you know what? I did not do what I needed to do. And I think that kind of addresses a question in the Q&A from Katie about PDs kind of being part of the harms of the criminal justice system. And I think that if we are moving toward having to preserve the record in this way, just remember that it's not necessarily about you as a PD. Perhaps you have something to add to the record about your lack of funding, the fact that you have more cases than what would ever be recommended under, the ABA or any other standard. I guess also the only other thing I'll add is that I formally, before I went to law school, I taught special education for 5 years. And what concerns me particularly about Ramirez's claims is that, are we going to expect somebody who has some sort of diminished capacity or a mild intellectual disability to have the wherewithal and the understanding to preserve their own claim, which is so crucial in these death cases? I mean, that is answering a question with a question, but something that is particularly disturbing to me.
Professor Washington.
I guess all I'll say is that to me, this also raises more questions than I have answers. I did actually think about the same phrase about falling on your sword earlier, right? And I think that's absolutely what it is, right? I think as public defenders, we understand what the workload is and what is expected of us, right? And I think not taking personal when clients are bringing these claims, especially in light of this decision, is going to be key, right? And I think that was true before this decision as well, right? Being able to acknowledge that, yes, people make mistakes, and certainly public defenders who are overloaded are going to be making mistakes, and being open about that and even potentially making a record about that on behalf of a client, I think is a good idea.
Great, thanks. And thank you for weaving in that question from Katie. Our next sort of question would be to think about where judges fit into all this. But I wonder if we could think about judges and continue to think about public defenders too, and sort of a broader thinking about the role, let's assume just really well-meaning judges, the broader role of people who are in the courtroom trying, but might be still a part of the harms of the system in whatever way you think about harms. So here's a question about judges, but I'd also invite us to keep thinking about the role of public defenders. We haven't mentioned prosecutors. We could bring them in here too. But here's a question that Lyle put together about where judges fit in. When a judge fails to report attorney misconduct to the bar, either that which results from prosecutor misconduct or ineffective assistance of counsel, does this undermine legal ethics? In other words, if court actors engage in unethical conduct and are not held accountable by the court or their peers, and are allowed to continue practicing law in a way that disadvantages defendants, does this mean the ABA rules of professional conduct are superfluous to the Sixth Amendment? And I just want to add an addendum to that question, which is that Lyle's law review article that's coming out does some really brilliant work around thinking about the ABA standards and helping us recognize that they're not perfect either, and that maybe they're a part of this. So Lyle, do you have thoughts on this question?
Yes. So this question, is kind of broad. I understand that, but at the end of the day, we're talking about the underlying morality of the actions carried out by an attorney, whether that's defense attorneys, prosecutors, or judges. By losing sight of that morality as it relates to actions carried out in court, oftentimes mistakes are made, but sometimes those mistakes aren't mistakes at all, but intentional actions which undermine the public trust in the way the legal system works. I think I would like to raise a point in relation to this question. I was in a discussion with a law student recently, and she was telling me about this, I think it was the legal ethics class she was taking, and it was a question had been posed by the professor where there was, if a prosecutor engages in misconduct, I believe it was in relation to jury selection. If a prosecutor engages in misconduct and there's nothing really said about it by the defense attorney, and the judge doesn't seem to acknowledge it isn't really misconduct if it's not caught. And it was responded to by another student who basically said no, and the professor was okay with that response. And I was kind of baffled by this when the student told me about it, because we were having a discussion about character and fitness, which is completely integral to the admission in the bar. And we got to discussing that, there's reviews of an attorney's character and fitness because it totally relates to misconduct and also sometimes ineffectiveness that goes on in the court. And this relates just as much to judges as it does to the defense attorneys and prosecutors too. But there should be a review of an attorney's conduct over time that relates to that character and fitness that you have to pass it to make the bar. And I think this review would go a long way toward at least maybe reducing some of the problems that arise with ineffectiveness of counsel and hold attorneys to greater accountability. But that, of course, starts with a judge. And when it's not the judge and it's not, say, an ethics committee or it's not the state bar, then it absolutely has to be the attorney's peers. And when it's not those peers, then we have a much deeper problem with the criminal legal system itself, because there has to be some kind of accountability for those who are supposed to be holding other people accountable.
Mr. Washington, do you have any thoughts about these questions of accountability?
Sure. So I'm actually really curious what other folks think about this question, what their immediate reaction to this was, because I have to say that my immediate reaction was sort of that I would feel a little bit nervous about judges sort of making those determinations and monitoring defense attorneys, because I could see a world where we're monitoring sort of the other end of this, where maybe what judges then do is sort of flagging the attorneys who are representing their clients zealously, or who are sort of disagreeing with the settlement that's on the table. And I've seen that more so actually in other contexts in a family court a lot, but where you walk into the door, into the courtroom the first day, and a judge more or less says, we don't litigate these matters here, right? And then sort of monitors over the course of the representation how zealous you're representing this person. And that worries me because I've seen cases where judges have reported things like that, but on the other end of the spectrum. But that's maybe sort of my general skepticism about system actors, which also includes public defenders, which brings us back to this question in the chat, right? But giving sort of judges more power to monitor defense attorneys' conduct, I think in some cases could work and lead to good outcomes. I worry about them then sort of monitoring attorneys who do fight for their clients. I think I said at the beginning that I focused a lot of my studies on comparing the German to the US system. And the German system, the judge is very much doing this, right? We don't actually know the concept of ineffective assistance of counsel, and it's because the idea is the judge is monitoring everything, right? And as long as there's sort of this judge in this role and making sure everyone is being held accountable, why would we sort of worry about this? And so I've seen sort of in other systems trends like this that worry me.
Molly, what do you think?
I think, yeah, that's very interesting. I also echo the concern about judges. Well, certainly some of them that I've been in front of having kind of this extended power to marshal attorneys that they think are not behaving in whatever way they think they should behave. But I thought that this question was particularly interesting because it brings in rules of conduct. All of us, we've read the standard for effective assistance. We read these cases and oftentimes it's shocking. But then again, some of the cases that decide what is or what is not prosecutorial misconduct is equally shocking, right? So we have this precedent that allows a lot of behavior that I think most of us would not think to be analyzed the way it ultimately is in the courts. But then you look at the rules, and I thought this question was interesting because I went back and looked at the rule about reporting attorneys, and I think it's ABA 8.3 or 8.4, and it has like a caveat where it says an attorney should report another attorney if they engage in professional misconduct that raises a substantial question about their general trustworthiness or honesty, right? So what this question prompted me to think about was how, yes, these rules, just like our precedent, kind of enable us to not report each other, right? Even if we see professional misconduct, it could be the kind of professional misconduct that the rule doesn't require being reported. So I don't have much of an answer, but I thought it was a really well-written and thought-provoking question.
Professor Hoag-Fordjour, what do you think?
Yeah, I started to do some research on, where do we get the ABA guidelines from? And they were promulgated by a bunch of super privileged lawyers, pretty much all of whom were white and male and had access to wealth and didn't really have interaction with people that were charged with crime except for their clients. And I think a lot about, what if indigent clients, people accused of crime, participated in drafting the ABA guidelines. I also took a look at the rules, the model for a code for professional conduct, and that was based off of a single state's sort of code of professional conduct, which was drafted by an early segregationist, a former Confederate general in Alabama, who was really an ardent supporter of white supremacy. And I think that, we are actually still relying on those canons of professional conduct. And, as it relates to judges and their role in potentially policing the conduct of defense counsel. And I don't have a lot of faith. A theme that we talk a lot about in criminal procedure adjudication is that the criminal legal system places a really high interest on judicial efficiency and judicial economy. And in my practice in Tennessee, judges would appoint lawyers that they knew were going to do the bare minimum and not file pretrial motions and not raise objections, and they would keep things moving. And so time and time again, I saw a lot of repeat trial lawyers who have been appointed to represent my clients, all of whom were sentenced to death. And it was like, I understand why this judge was appointing these lawyers, because it was going to be a short trial. The judge's docket wasn't going to be full. The quorum wasn't going to be occupied by a lengthy capital trial. And so I'm pretty pessimistic when I think about, judges potentially being the ones, to provide some meaningful intervention. I also think about the earliest effective assistance of counsel case, which didn't tell us a lot about what constitutes effective representation, but it was Powell versus Alabama, which was one of the three cases that came out of the Scottsboro Boys trial. And there, the trial judge, to give the appearance of due process, appointed the entire bar, putting up quote signs for Lyle and others not clued in visually. But this idea of appointing the entire bar to represent these children that were facing capital charges. And of course, without any single attorney being accountable, the US Supreme Court did find that was ineffective in terms of appointing counsel, but not necessarily giving guidance on counsel's individual conduct. And so I think a lot about, what actors, can provide meaningful intervention. And it's the way the system is set up. It's really disempowering for individual clients, and judges have a disincentive to appoint lawyers that are really going to dig in and provide zealous representation.
Yeah, I think, thanks for that. The history of the ABA guidelines, I think, is really useful to think about, especially, again, keep an eye out for in Lyle's article, some really critical thinking and analysis about even people currently in the ABA and how they're going about thinking about their rules. And so the next question is going to be about another ABA guideline, and this one circles back to the attorney-client relationship. I will say, as we're thinking about this question, we did have a great question before. If anyone else wants to add in questions or things you want to make sure we hit on, since we're at 5:46, please do. It could even just be like a topic. Feel free to throw it out there. So here's another ABA guideline to think about. ABA guideline 10.5 is about the attorney-client relationship. And when you read it broadly, it says things that sound very good. It requires you to try to develop a relationship with your client. It requires you to engage in dialogue. And it lists different ways that you can do that. So on its face, it may not jump out as problematic, but Lyle points out for us that in the ABA's commentary, there's an assumption about people who are called capital defendants, or people who are appealing capital convictions might be like. So here's what it says. It says, the prevalence of mental illness and impaired reasoning is so high in the capital defendant population that it must be assumed that the client is emotionally and intellectually impaired. It says that in the commentary to the ABA guidelines. So Lyle, I would love to start with you, and it might jump out at people, but what is it about that moment in the commentary that jumps out for you? And then maybe we can go around and think about that assumption and how it might be different, for example, as you suggest, between how law enforcement are trained to approach people who are unarmed, especially people of color, who often end up as casualties of other kinds of assumptions.
Well, the problem with any assumption is it eliminates other kinds of thought about that person. And when we're talking about defense of a capital case, we're talking about defense tactics, we're talking about strategy. So if you're assuming a client is emotionally and intellectually impaired, you're automatically going to be focused on mitigation. You're going to be doing mitigation-centric work. And the problem with mitigation-centric work is not that it's helping the client, it's that it implies guilt. And this is problematic for anyone who is claiming to be not guilty, who is in fact claiming that they are wrongfully charged, that they're wrongfully convicted. And we know this is true because of well over 100 people have been exonerated from death row at this point. If you're training people to go into their defense work with an assumption about how a client thinks, how a client is emotionally engaged or disengaged from a particular offense, you're going to draw other assumptions from that. You're going to say, okay, well, if this client is upset about something, maybe it's because they're guilty, not necessarily rooted in fact. And that's, that's problematic on a number of different levels. I guess with regard to comparing that to the way law enforcement responds to unarmed people and make those snap decisions in the moment, and oftentimes end up killing those unarmed citizens, it seems very different because the thinking is reactionary, but this isn't really that different because the thinking is equally reactionary every time that you use something to base that thinking. You would think that attorneys who engage in defense work are slower to thought, that they're more methodical, that they're more critical in their analysis of the facts as they are. But we know that not to always be true. We know that because there are plenty of cases where ineffective counsel has overlooked facts about guilt and innocence because they were focused on mitigation, and they were focused on mitigation maybe because they were trained to be focused on mitigation, maybe because it was assumed that the person that they were representing was intellectually impaired or emotionally unstable or any number of characteristics that maybe weren't there from the beginning.
Thank you for that. Professor Hoag-Fordjour, do you have reactions to that?
Yeah, it's interesting. I think about the ABA guidelines so much more critically now that I'm no longer in practice. But these served as my guidebook in post-conviction litigation. And I think about the context in which the 2003 guidelines for death penalty representation were created. And we had, signaling from the Supreme Court in Strickland versus Washington that they were going to turn to the ABA guidelines to help them understand or figure out what sort of competent, reasonable representation was. And the guidelines are pretty bare bones. And so folks in the death penalty post-conviction community thought, well, let's participate in drafting. So now we can put some sort of bones on the meat, I should say meat on the bones of the ABA guidelines. So we can say, look, trial counsel, wasn't aware that the client had intellectual disability or had a mental health issue or had elements of their background that needed to be investigated to put forth as mitigation evidence. And the ABA guidelines told them that they should assume that they should know these things. And because they didn't know, they didn't follow up, they didn't investigate, they didn't present. Court, you can find them ineffective. But Lyle has raised many of the problems with this presumption. And I do agree with him that most capital post-conviction lawyers are focused principally on the sort of sentencing part of the trial. So client's guilty, I'm going to put all my attention and effort and energy into potentially getting some sort of relief on the sentencing phase of the trial. And as my students in adjudication on the call, we just talked about the bifurcated nature of death penalty trials. And perhaps with this assumption, it can reinforce post-conviction counsel's focus on just the sentencing phase and not to work as diligently on that guilt, not guilt phase of trial and overturning that conviction. So I think about it sort of wearing two hats, as a post-conviction lawyer that really leaned heavily on pointing to the ABA guidelines to say, look, these are all the ways that the trial counsel failed because the ABA guidelines from 2003 and the mitigation supplement that was promulgated in 2008 said trial lawyers should be doing these things and they didn't. But I really do see the shortcomings that Lyle has pointed out on this end of things.
Well, I was going to just say we have anonymous attendee has a question, and I actually align with anonymous attendee because like them, I was not aware of this commentary. So they say they weren't aware of the commentary, as I was not, and find that it's overbroad, negative, stereotype-driven language is really frustrating. I wholeheartedly agree. And I think it's interesting language too. It talks about mental illness, right? You can imagine that perhaps if you're sitting across from somebody who's on death row or serving a life sentence or in any other situation where you're working on their case as post-conviction counsel, are you going to interpret their frustration or their depression as this mental illness, right? And then veer into this direction of solely going toward mitigation rather than kind of looking past their demeanor or whatever you perceive as their personality and actually still dig into the facts. I think it really raises tremendous issues, and it does give attorneys seeming leeway to kind of deal with those issues rather than the issues underpinning the case and the convictions. So the other thing that this attendee comments about is that there's a solution, and it says that the solution to this issue would be to involve your mental health experts. So as a federal defender, we had wonderful resources, and I worked closely with social workers all the time. I didn't have the benefit of that on the state level. Well, not to that extent. And I think you just have to be careful to immediately involve your social worker simply because maybe your client presents, like I said, with some frustration or what you interpret as a depression, right? Some of that is to be expected. And there certainly is an incredible place for social workers in our line of work. But I do think that it's dangerous when you couch it as a solution to the issue that all of these individuals are presumed to have mental health issues or other cognitive disabilities. But again, I had not seen this until reading this question for this presentation.
Professor Washington?
I'll just add that I echo that. I think this is kind of a good example of the pathologizing of people groups of people, often racialized people, and people who are, poor often, right? I think it's a good example of that. It obscures sort of what is actually going on. I think this example is really great. Is this actually frustration with you as an attorney and with the system? And it allows the system to sort of legitimize whatever the narrative is that the system actor, whether that's the lawyer or someone else, encounters or interprets sort of that interaction to sort of represent. So I think that is sort of dangerous because it's such a self-perpetuating logic. Now everything that doesn't comport with whatever, or sort of comports with this idea that there's pathology, is sort of viewed in that light, right? My client is not responding in this way. That means clearly, they don't understand what I'm saying, right? And that takes away from the things that we talked about, or sort of legitimizes taking away from what we talked about at the beginning of the panel, which was client-centered representation, right? If I can say, well, no, I can sort of disregard some of these things because of this label I've now attached to this person. Yeah, I think that's sort of really, really problematic. And I think I'll say, sort of in response to the question in Q&A, yes, social workers can be sort of part of the carceral state, right? I think a lot of people have sort of called hospitals, not limited to social workers, but people who work in hospitals, doctors, other folks, part of the shadow carceral state, mandated reporters who sort of engage in reporting and have collected sort of or documented things about clients over many years, which has led to people walking around with labels that may or may not be accurate for, large parts of their lives.
Great, thank you for that. So we're waiting for Lyle to rejoin us. He was disconnected for a moment. Oh, he's back. So we have only about 2 minutes remaining. I'm sorry we didn't get to all of the questions, but I've learned so much from all of you. So I think what I'd love to do for the last couple of minutes is thank everyone for being here, but pass it back to Lyle for final thoughts or sort of ideas or questions you want to leave us with.
Thank you for all of you for participating today, for listening to the things that I've had to say, and for providing this, this forum for us to discuss these issues. I think by discussing these issues, by talking about conflicts that arise, by finding solutions, and by being willing to about them, that we can ultimately provide better defense and better communication and maybe even a better outcome in court. I would appreciate it if all of you were, when you get the chance, to read State of Delay, our outdated capital post-conviction defense tactics undermining effectiveness of the attorney-client relationship, when it's published by the Journal of Law and Policy, and to spread it to as many people as you care to spread it to. It is very important and talks about all the issues that we've discussed today on much greater detail. I'm sorry if I sounded a little bit vague at times. I'm doing that intentionally to protect some of the topics that are discussed in the article itself, because they are very much still active topics. There's a particular case that I'm covering that is still very much on appeal, and I am hopeful that a positive outcome occurs in that case. But that's what makes what we're discussing so very important, and I'm grateful to all of you for it.
Great, thank you so much to you and for your writing and for everyone who joined us this evening. Thank you.
Thank you. And especially Molly and Lyle for sharing their expertise with the BLS community.
Well, it was an honor. Thank all of you as well. Thank you.
Thank you, everyone.
Thanks.
Thank you.